Okay, testing, testing. Can you hear me now? Let me know in the comments if you can hear me. No sound, appreciate that. MC222. I got it, thanks. Can you hear me now? You should be able to hear me now. Can someone put in the comments? Someone let me know. Can you hear me? Have we got sound? What's up, Fly? Can you hear me? Have we got sound? Right, we got sound. Okay. Can you see what we've got on the screen? I'm sorry, there's probably a better way of doing this, but I want to be able to see the document and see if anyone's commenting. Okay. This is the response to Norbes' $40 million lawsuit. This is the most, so as you can see, they've responded by saying, dismiss the complaint. Their response is, it's not a valid complaint. He hasn't satisfied the legal criteria. He doesn't have the evidence he needs, and we're asking the court to dismiss. Okay, so this is the memorandum of law in support of the defendant's notion to dismiss. So what this is, oh, what's up, Battle Rap Trap, Henny Man in the building, my co-host, salute, thanks for tuning in. So what this is basically is the document saying why the court should dismiss Norbes' lawsuit and why they're saying there isn't enough evidence for it. So we're going to go through it page by page. It's quite a long one, but it's a good read, to be fair, and it's an important one. I started reading Norbes' 21-page document, and 81-page document. And after I got through about sort of, I don't know, 15 emails saying there's an event, or 15 descriptions of an event listing everybody who was there and no relevance or evidence, I sort of left it there, and the wording of it, and it just let me know I didn't need to carry on. This is somewhat different. There are as well, as you can see, lots of documents. So there's the motion that's been filed. There's also the memorandum that we're going to read. There's an affidavit from Beasley, and there are legal registration documents, and then also a couple of text messages, the press release that the URL put out firing Norbes, and Norbes' complaint as an exhibit. So let's get into the meat and potatoes. This is sort of the case law that they're using and the statutes that the lawsuit relies on. So they're saying Norbes was a talent scout. Oh, why can't I make this yellow? Blue is so harsh on the eye. Blue was a talent scout. They were forced to cut ties with him due to his professional conduct. He was an independent, an at-will independent contractor. What's up, JJ? Nice to have you tuned in. He was an independent contractor, and the plaintiff now masquerades before this court as if he were a partner in the LLC. They're saying the Ultimate Rap League is an LLC, and Norbes was masquerading as though you were a partner in it. Try as he might to conjure the appearance of a partner whose alleged oral contact was breached, whose name was defamed, and whose right of publicity was violated, the plaintiff's rambling 415 paragraph complaint utterly fails to allege sufficient legal basis to survive this motion to dismiss. So basically, he's got no evidence. It utterly fails to fulfill legal criteria. The dispute revolves around URL, the premier platform for up-and-coming rap artists to showcase their lyrical genius in front of live audiences. Then it gives you background built by hard work and financial contributions of Troy Mitchell, Eric Beasley, and Gene French. The URL's genesis was in 2002, Smack DVDs. It was Mitchell's New York Corporation. And then the individual defendants formed a separate liability company through which they conducted business. So sometime after 2002, doesn't say. So over a decade ago, the plaintiff, Norbes, was operating as a talent manager for a rap artist. And in that capacity, so as a talent manager, began to communicate with the URL. After that, Norbes provided his services as a talent scout on an event by event basis. Is aspiring to boost his own standing in the hip hop world. The plaintiff enthusiastically trumpeted Ultimate Rap League events by creating an advertising and posting on social media. So basically saying he was doing some marketing stuff to boost his own name out there. He never, over the years, exercised managerial control, never shared in the business profits or losses, never contributed capital to the business, that he put no money in, never signed a partnership agreement, never once claimed to be a partner. To the contrary, in public interviews, the plaintiff has expressly acknowledged that the individual defendants, Smack, Beasley and Cheeko, were the owners of the Ultimate Rap League, and that he had played a role more akin to a general manager. So they're saying he said this publicly. At the time, Norbes' behaviour at events devolved to unprofessionalism. He was unprofessional. After he got in a fist fight with a rap artist scheduled to perform, so that was Twerk at Genesis, they ended their business relationship in 2002, April 2020, with that press release, and wished the plaintiff well in his future endeavours. Now, in this 88-page document, Norbes falsely boasts that he was a general partner, yet the complaint is devoid, this is quite important stuff here, the complaint is devoid of allegations necessary for this court to find that a partnership existed, i.e. that the plaintiff had an agreement with the defendants to share losses incurred by the business, or that the business was administered through the partnership. Norbes is saying there's a partnership and I was a partner, rather than the validly registered LLC, which the plaintiff incongruously named as a defendant. So basically, URL are saying, yo, we're not a partnership, we are a registered LLC. So how can we be in partnership with you when we don't even have a partnership? And you can't name the LLC in the lawsuit if you're suing us as a partner. You can't have a partnership. It can't be both. It's either an LLC or a partnership. I think that's what they're getting to there. I'm not a lawyer, but that's what they're saying. And on top of that, the plaintiff also lodges deficient claims for defamation, which fails to allege a falsehood, and for violation of the right of publicity, which fails to mention that it was plaintiff who commissioned and posted the publication. So they're saying none of it is valid. Just as he masquerades as a partner, the complaint, listen to this bit. Just as the plaintiff masquerades as a partner, the plaintiff's complaint masquerades as a complaint. So he's pretending to be a partner and his complaint is pretending to be a complaint. It's all fake. In rap parlance, the complaint's beef lacks realness and is a whack attempt to bite what is not his. Without allegations sufficient to state any of its 16 causes of action, the complaint cannot launch any battle with which this court can adjudicate. Unmasked, the complaint is revealed for what it is, a cynical ploy by which the plaintiff hoped to illegitimately score rap's most hyped prizes, money, fame, and revenge. Always a whole saga. Plaintiff is entitled to none, and his complaint should be dismissed in its entirety with prejudice. And I believe that means he can't bring it back. Everyday Rich, what's up? What's going on? So if anyone's just jumped on the stream, what we are doing is we are reading through the URL's response to Norbes' 40 million lawsuit. This was just filed yesterday, and I'm surprised that no one's sort of talking about it yet, just because it's a good read. Lots of people talked about the 81-page document, and yeah, so we're going through this together as a family. So then it sort of talks about the background. Smack produced a video series, so it's talking about Smack DVDs. In around 2004, Beasley, who'd been around the block, joined up. In around 2006, Cheeko came on board. They all contributed money on a rolling basis to fund the production of new smack videos amounting to thousands of dollars over a period of years. So they all put in from the beginning. At the end of some of the interviews and the smack videos, the artists host rap battles in which, so that was the smack DVD rap battles. It was a distinctly popular thing on the DVDs. Smack used to hang them out from the back of a trunk. Smack maintained a corporate bank account, registered a trademark for Smack. And by his own admission, so Norbes says he had no involvement whatsoever with Smack White or the battle rap videos the company produced. And in fact, the plaintiff, so Norbes, doesn't allege any involvement before 2009, which is a year after Smack had launched Smack White, so the enterprise business, and grown it with the help of Beasley and Cheeko. In 2009, DVD's sort of popularity waned. They started doing videos that were just battle rap. They were doing live audiences around the country. They were originally branded as Smack Presents URL. URL is the home of Smack on YouTube. They registered the domain name and launched the YouTube channel. Norbes had no involvement with the website, the social media accounts, and never ever had any access to any of those accounts. So not only did he sort of not have partnership, he didn't even access the account. So he would repost stuff on social media, but he wasn't even involved in posting stuff himself on social media, never had access. So they initially conducted their business through URL branded, they conducted URL events through Smack White events, and then and venues attributable to the URL's Rap Leage page with it. So revenues, sorry. So the money went into the Smack White bank account. The Smack White account was a business account from the sounds of it. So then they formed in 2013 a new separate business entity to do URL business. They filed June 2013, filed articles of organisation, basically the legal documents, setting up their business with 3 members, Smack, Beasley and Cheeko. Then a year later, they formed, or they executed, the LLC operating agreement, which memorialised that they were the sole members of the company and the rules governing their business. They also set forth express restrictions on the admissions of any new members or the assignment of membership interest to a third party, which could only happen with the written consent of the other members. And then this here refers to an appendix, or what do you call it, an affidavit, or it's referring to an affidavit, but basically they're exhibiting the legal document, the legal sort of business registration document, which says that if we're going to add anyone to this LLC, then we need written consent of all the other members. So there should be a document which says, geez, that might be, yeah, there should be a document which says if anyone else is to join, legally, we all have to sign and say, yeah, that's cool. In 2017, they formed a separate limited liability company in New York, URL LLC. And now that's the business that they conduct their business through, or that's the company, that's the legal entity that they conduct their business through. It's the 3 of them again, Smack, Beasley and Cheeko. Gives you a bit more detail here. They all hold a third in there. They're all equal partners. Plaintiff Norbes was not involved in the formation of any of those entities, never contributed any, he never put any money in. And as reflected in the documents that started the company, he's never even mentioned, much less listed as a shareholder or member. So he's nowhere in the formation documents. In 2009, he was the manager for Math Hoffa. So in fact, let's just recap on that quickly. Basically, they're saying there, it's easy to follow. We formed various legal entities over the years. At no point was Norbes involved in any of those. And in fact, we were doing some stuff before we even met him in 2009. So he was a maths manager. That's how they came into contact with him to book Math at an event. As the complaint, so as Norbes' complaint recounts in exhaustive detail, over an approximate 10-year period, defendants made periodic use of the plaintiff's services as an evaluator and recruiter of up-and-coming battle rappers. So basically it was a talent scout. The plaintiff would appear at Ultimate Rap League events in an effort to boost his own public profile and to further his career as a manager of artists. So he attached himself to big himself up and his artists. He also assisted in the design of promotional materials, so flyers and stuff. I think there's an exhibit for that. And on an ad hoc basis, so as and when, the URL would make small payments to Norbes via cash or electronic transfer in compensation for his services in arranging the performances of particular battle rappers. So as a manager, we would pay him. When we hired his artists, we would pay him. In other instances, they would provide Norbes with a portion of revenues generated by live ticket sales for Ultimate Rap League events while retaining all rights in the video footage and accompanying streaming revenue. So they're saying for some instances, the defendants would provide him, so Norbes would get a portion of the live ticket sales while retaining all rights. Okay, so they kept all the rights to the footage and the stream, but sometimes Norbes would get a bit of ticket revenue. Over the course of that business relationship, the URL made no secret of Norbes being a talent manager and a promoter, but he was never a partner. At no point did he agree to. At no point did Norbes agree to share in the profits and losses or make any contribution to the URL LLC or exercise control, nor does the complaint. So it's saying he didn't contribute, he didn't make any losses, he didn't put any money in, he didn't have any control over management. And on top of that, he doesn't allege that he did. He doesn't even say, his complaint doesn't even say. That's how, what did they call the complaint? Well, that's how bad they're saying the complaint is. He doesn't even say that he did. So in 2020, early 2020, they became concerned by Norbes' increasingly unprofessional behaviour. There was a fist fight between Norbes and Twerk, and they fired him, basically. That was the end. So now they're saying, pursuant to, what's that, civil practice law rules or rules and law, I don't know, pursuant to some civil law court ruling, a motion to dismiss based on documentary evidence should be granted where the documentary evidence utterly refutes the plaintiff's factual allegations, conclusively establishing a defense as a matter of law. So basically, you need, pursuant to this law, you should grant this motion to dismiss. You should throw out Norbes' lawsuit because our documented evidence completely disproves Norbes' allegations. So we've got a solid defense. We can't, we disprove it from in our motion, throw it out. And then it sort of goes into the case law. It should not accept legal conclusions or Okay, so although a court liberally construes the pleadings on a motion to dismiss, it should not accept legal conclusions or factual allegations that are flatly contradicted by documentary evidence. So what they're saying here is basically, we've got legal documented evidence of our formulation of our company. We've never been a partnership with LLCs. We've got written documentation saying, you know, no one else can come and join unless we all sign. And there isn't anything. He hasn't presented any of that. There's no evidence. So because of that, you have to dismiss. You can't accept even though you have to be liberal with pleadings, because it's sort of the start of a case, I guess, saying, you know, you have to, when it's indisputable, you need to throw it out. It sounds like Norbes knew nothing about these documents. Maybe he didn't, but at least one of them, I don't have it on this computer, but the LLC formed in 2017 in New York. I've got that document. It's a very public document. You can see that at least from 2017, the URL was set up as an LLC and not a partnership. Don't know why the lawyers don't have that. I guess it doesn't help them to have it, so they wouldn't necessarily present it. It doesn't make much sense. But then I'm not a lawyer. I don't know the ins and outs of this. I'm just reading this stuff. I'm using sort of common sense and a tiny bit of legal knowledge, and I have no knowledge at all of US law, never mind New York State civil law. So Norbes says that the URL LLC is a limited liability company organized under the laws of New York. By itself, this admission, so I guess that's what I've just said, is fatal to the plaintiff's allegations that he is a partner in the URL LLC, as the URL LLC is not a partnership. So Norbes, in his own suit, says the URL is an LLC. It can't be both. So him admitting it's an LLC is fatal. Throw it out is what they're asking for in this suit, because he's admitting it's not a partnership. I don't know if then he can then sort of, if they throw this out, if they do it without prejudice, that means he can't come back. But I don't know if that means that he can come back and sue them as rights to the LLC. I don't know. Again, no legal knowledge. Partnerships and LLCs are not interchangeable entities or substitutes for the other. To the contrary, they are distinct legal entities. You can't have both. They can't be both at the same time. Then it goes on to give the legal definition of the two. And then it goes on to tell you where it lists the case law for where the New York courts have dismissed claims made under the partnership law when the claim is refuted on its face by the existence of a validly organized LLC. So basically, New York, they're showing case law in the past when this has happened, when someone has tried to sue as a partner, a company which is a registered LLC, it's been thrown out, it's been done there, this is what you should do, is what they're saying. On this basis alone, plaintiffs' claim for relief under the Partnership Act are incurably deficient. Wow, legalese is so harsh. Incurably deficient. Incurable. There's no cure for the amount of deficiencies in the plaintiff's complaint. Throw it out is what they're asking, and must be dismissed. Incurably deficient. Wow, that's harsh. The formation of a partnership requires a standard purpose and knowing mutual assent by all parties to the partnership. No person can become a member of a partnership without the consent of all partners. So unless we all know we're partners and we all agree, we're not a partnership, bro, is what they're saying. As a species of contract, partnerships are normally reduced to writing, although it can be an oral agreement. However, a party claiming, so if you're saying we've got an oral partnership, then you, the party claiming that, bear the burden of proof of proving the indica of such a relationship. So you need to show that there are other things. If you've got this oral partnership, there should be things. You should be sharing in profits and loss, management and organisation. You should be able to prove those things if you have a legal partnership. Prove it is what, and the burden of proof is on you. And emails listing events and who attend is, they're saying, isn't proof of partnership. So then it goes on to sort of give more case law where that is the case and where lawsuits are dismissed under those circumstances. Oh, the plaintiff lards, I imagine, is to add extra fat. Lard is fat. The plaintiff adds extra fat, which is I'm stepping out of myself here. You know, this is not London Jen, the newsreader. This is London Jen. He chopped it up with Norbes, unfortunately, and knows what a wanker he is. What a perfect word for such a wanker. he lards his complaint. I could so see Norbes larding, yeah, it works. He larded his complaint. Oof, get that larded complaint out of here. The plaintiff lards his complaint with an interminable string of calendar entries regarding, oh, this is vicious. The plaintiff lards his complaint with an interminable string of calendar entries regarding URL events held over the past decade, but fails to allege any substantive facts that would support a plausible claim that an oral partnership agreement existed. Foremost, the plaintiff fails to allege any facts that could support an inference. So you can't even infer. There's nothing to even say, oh, those things make it look like he entered into an agreement. And an agreement to jointly share losses incurred by a partnership to run the URL. The plaintiff includes one conclusory sentence that he and the defendants shared losses on an equal basis, but alleges no facts or specific instances that would support this allegation. So to satisfy the most minimal of legal requirements, he's put a sentence in there saying, he and the defendant shared losses on an equal basis, but he's got no proof of that. There's no bank statements, there's no messages talking about who was going to get what, there's no money transfers, there's no accounting, there's no nothing. Moreover, the plaintiff's conclusory statement that he shared in losses is vitiated, I don't know how to pronounce that word, by his admission that he had no knowledge of the URL's finances, right? He says in there, I don't know what they were making. Norbes says in his lawsuit, I ain't got no idea what they're making, yet at the same time you're saying you're a partner. I said this, whenever I've talked about this, I've said this, how can you say you're a partner, but you have no idea anything to do with their accounts, their finances, you don't know what money they have, yet you're a partner. Plaintiff's failure to allege this indispensable element mandates dismissal of his partnership claim. It mandates it. It means you must. His failure to allege this indispensable element means you've got to throw it out. Norbes fails to indicate the losses he would be jointly and severably liable for and points to no provision in the alleged agreement for sharing of any losses. Instead, there is nothing more than a conclusory allegation that any losses will be borne equally. Then quotes some more case law, I think, and says where it has to be thrown out under those circumstances by case law. He also fails to make any substantive allegation that he exercised joint control in the management of it. He alleges that he provides services as a talent scout and hosted events, but such actions are insufficient as these low-level services are not the equivalent of controlling or managing URL LLC. Critically, the complaint conspicuously fails to allege that Norbes participating in any of the business decisions, including, for example, the deciding frequency or locations of battles, basic management decisions, what we doing, where we doing it, when. He also doesn't say that he participated in any business meeting with any of them or their content partners. He also fails to allege that he had access to or that he managed any of the streaming platform social media accounts, or that he had access to their bank accounts, contracts, or bookkeeping or tax matters. Then it goes on to give you case law, which tells you under those circumstances, throw it out. Similarly, Norbes fails to and cannot allege that he contributed capital to the supposed partnership or that he contributed capital to Smack White, or so any of the legal entities. More case law under that circumstance, throw it out. Whilst Norbes, finally, so we're getting to the end, whilst Norbes alleges that he received profits from certain URL events, this is demonstrably incorrect. We can prove that's wrong. URL compensated Norbes for independent contractor services he rendered, but such payments were based on a portion of revenues, not profits, from live ticket sales. So not profits from events, not profit from streams, but live ticket sales. He got a portion of the door. They gave the man a cut of the door, is what they're saying. Revenues and profits are not the same, is what they're saying. And partnership law, which is the law that by which Norbes is trying to file this suit, partnership law says that specifically instructs that the compensation of an employee with a portion of revenues does not rise to the level of profit sharing needed to establish a partnership. So they're saying, even if Norbes was right suing under partnership law, and he's not, because we're not a partnership, and if we were, he had no part in it, showing that you've got a portion of revenues doesn't establish profit sharing. Gives more case law. Seeing through the plaintiff's irrelevant chronologies, it becomes apparent that Norbes has failed to allege the essential elements required to plead the existence of an oral partnership agreement. Consequently, Norbes' claims directly premised on the existence of an oral partnership agreement should be dismissed. Plaintiffs' quasi-contractual claims as a matter of law because there was, the claims fell because there was no partnership. So as a matter of law, no matter any evidence, no matter anything else, there was no partnership. You can't sue us for, you know, money that was due to you as a partner of a business that wasn't a partnership. So you have to dismiss it. Breach of fiduciary duty, I can't say that word, I should be able to. There is no fiduciary duty owned, throw it out. Brief of, okay, so these are the things that Norbes is sort of asking for. He's, you know, the things that he's saying exist. They're saying this doesn't exist. There was no implied covenant of good faith because it implies to parties who are partnership. There was no contract. No covenant of good faith can be breached because it didn't exist. Promissory estoppel. Some legal term which they're saying doesn't exist, throw it out. I'll read these in more detail later, but basically they're saying, similar to the baseless facially deficient quasi-contract claims, the plaintiff's tort is embellished. The plaintiff's complaint is embellished with tort claims that are plainly alternative guises for his deficient membership claims. Upon a determination that plaintiff has failed to plead the implausible existence of an oral partnership, these claims must also be dismissed. Okay, so basically they're saying, along with his baseless contract, quasi-contract claims, his tort claims, so the claims that he's asking for money because of various other things don't exist either. And because of that, you need to also throw them out. Throw out the claims because, throw out the tort claims because just like the contract, there's no basis for them. Okay, misrepresentation. So this is more claims. He's claiming for misrepresentation and negligent misrepresentation. More stuff that he's claiming for that they're saying that he basically has no legal right to. Okay, there was 16 counts, weren't they? Did he have 16 bars? Were there 16? That's cute, 16 bars. I need to count 13. Defamation, fails to specifically, I hope I haven't just skimmed over anything good, but, you know, this is getting long now. But it is, you know, a document that feel free to find it and read it in its entirety and go through the exhibits. Okay, so the defamation claim is premised upon an April 28th press release. So the press release firing Norbes that stated, without insult, vitriol, or false statement of fact, we weren't lying, we weren't mean, we weren't aggressive or hostile, that we discontinued the relationship, the URL discontinued the relationship with the plaintiff, with Norbes. It included positive statements, included that the URL enjoyed the time of our professional engagement with Norbes and wished him all the best in his new journey. The anodyne press release is indisputably true. There's nothing there that you can say it's anodyne. There's nothing that you can say. And I said this, when the URL put out that press release, they did it because they knew there was nothing in there that was damaging to them. They ran that by lawyers first, and the lawyers said, it's not the nicest, but you know, you can't be sued for it. It was true. The relationship was terminated. It didn't state the driving reason for the need to end the relationship, which would have cast Norbes in an unflattering light. They're saying we didn't do that, and is not reasonably susceptible to any defamatory interpretation. Defamation is the making of a false statement which tends to expose the plaintiff to public contempt, ridicule, aversion, or disgrace, or induce an evil opinion of him in the minds of right-thinking persons, and to deprive him of their friendly intercourse in society. I'm saying nothing there. And then it goes on to say what they have to prove, and that Norbes basically hasn't proved it. The falsity of the statement is an essential element of the defamation claim. It's got to be false. So therefore, if the statement is substantially true, then it's an absolute defense. Throw that count out. And let's see if there's good stuff in here. It only contained the fact that it ended their business relationship. Okay. There's more. Plaintiffs' vague allegation that the defendants made statements to bloggers is not pled with the requisite specificity under CPLR. Plaintiff's defamation claim also makes the jumbled allegation that in interviews with bloggers, defendant Mitchell and defendant Beasley knew the statements would get out to thousands of URL followers, knowingly made the false and defamatory statements about the plaintiff. Despite spanning nearly 80 pages, the complaint does not identify which statements were made by which defendant, when the unidentified statements were made, or to whom the unspecified statements were made. Consequently, plaintiff's defamation claim fails to meet the pleading requirement. More case law. Count 11. Plaintiff has failed to allege a claim for right of publicity. Okay, there's all that is likeness and stuff. Case law for that. Talking about publishing his poster. Okay, there are 11 counts. So, for the foregoing reasons, defendants specifically request that the court dismiss all claims in the complaint with prejudice and grant such further relief as is proper. Now, they're basically saying his lawsuit doesn't contain any evidence. He's actually filing under the wrong civil laws, because we're not a partnership, we're a legal LLC. And he doesn't establish anything. There's no evidence to prove that he formed any sort of management decisions or any financial decisions in the company, and you need to throw it out. Now, I'm not a lawyer, but it looks good to me. Right, okay, how long are we going? 40 minutes, okay, all right. So then we've got Beasley. This is Beasley's affidavit in support to dismiss the complaint. So he says he's a member of the URL LLC, as well as someone named in the action. He knows Wagwan. He's saying he's doing it into support. He's talking about his background, and then 2004, we set it up. Me, Smack and Beasley put all the money in on a rolling basis. We all invested a lot of money. We started doing rap battles. We distributed the DVDs, yada, 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 Smack White. So he's just backing up basically what is said in the document. He's going on to refer to the legal documents, describing the battles and what they were doing and sort of the legal stages of their company. talking about the relationship to Norbes, and basically just backs up what the motion to dismiss was saying. The plaintiff, so Norbes, periodically appeared at some but not all events, events connected to rappers, or events with rappers connected to Norbes. They were not necessary to the success of the events. When he chose to event, it was generally to boost his own public profile and the career of his artists. He assisted in the design of some promotional materials, and they exhibit some. He didn't have access to any of the social media accounts. Sometimes we gave him door money, but made it clear that URL have retained all the rights in all the video footage and accompanying streaming revenues for the event. We've never been a partnership. We've never promised Norbes that he would be a partner or given him any sort of equity. He had no involvement in creating the website, social media, and never had access to it, never had managerial control, never had profit shares or losses. Why is that? Okay, because it's a signed page that he's signed and scanned and sent back. Okay, we fired him. Boom, that's it, is what they're saying. So yeah, like I said, I am not a lawyer. I don't have any knowledge of tort law in the United States. I don't know how likely it is that this motion to dismiss is going to be granted, but it looks legit to me. And like I say, I didn't even bother reading through the 81 pages of Norbes's document because there was nothing in it. As the motion to dismiss has just said, it's basically 81 pages of listing events, who turned up, sharing sort of emails which say absolutely nothing, least of all, you know, who was a part of it, who was, or who, you know, doesn't give any sort of indication or any evidence as to who was a partner in anything. So we shall see what the next thing is. I'm waiting with bated breath as to see what the court decide to do, but it does seem clear that or it looks like right now that the side of, you know, the evidence is on the side of the URL. The lawsuit was very sort of dismissive and gave lots of ground and accompanying case law for reasons to throw the suit out, and each count they gave reasons why. So I don't know how that 40 million is looking right now, but that's their response. So like I said, we shall see. I decided to go live because I've been following this since URL or since Norbes sort of filed the lawsuit. I've been looking for it, or since we've seen the documents, I've been waiting for it to be filed as a document in the court of law, or in the civil courts. Been following the documents that are uploaded, went to read the 81 pages, like I said, couldn't get through the thing, and I've been waiting for a response, and this response dropped yesterday, and yeah, I was waiting for people to start talking about it, and they weren't, and it's Norbes. So I don't like to be the first to go and talk about something I don't like. What I wanted to do was do a show like my Addy Boom show, go through things, go through it in you know, a measured way. But yeah, I've got a tough spot for Norbes. I wouldn't say a soft spot. I've got a very tough spot for Norbes. And yeah, it got me excited. I'm not excited, I can't say that. I'm not saying that, I'm still London Jen. I was interested in the update to the proceedings that were going on and felt like it should be talked about in a responsible way. So I decided to do that. And yeah, Norbes is a wanker and I don't like him. So here we are. But I think that's it now. Have I done enough? Have I not done enough? Have I gone through the document? Anyone got any questions? Anyone got anything to say in the comments? Should we go and look? In fact, actually, what I'm going to do is I think I'm going to go back and look over some of my. No, I won't do that. Actually, that's tormenting. I think, yeah. Anyone between the bars? You got any questions? JJ, you still in the chat? Anyone in the chat got any questions? What do we think? What do we think about Norbes' chances? Is Charlie still getting a cut of that 40 million? What are we doing? What are we saying? Do we think the URL have a strong chance of getting the case thrown out? Where do we go from here? Find out on next week's episode of Judge Jenny. Wouldn't it be funny if I was the judge? Ooh. Wouldn't it be funny? You never know who you're calling up and wanking to. You never know. Vixen is upset. Okay, I'm leaving Vixen out of this. I'm leaving Vixen out of this. I don't know. I don't know what Vixen's previous nor current affiliations with Norbes and his 40 million is. But yeah, no, I thought it was very interesting. In fact, I'm going to go and have a look because I read it sort of once through, and I love legal language that is very polite but so cutting and rude. Like, it's a battle. We got a battle on our hands. Like, this was, for me, this is a one-round body for me. If we take Norbes's bars, if we take Norbes's 81 pages and we put that against the 31 pages that the URL had, I would say that's a clear body. I would say that's a, but what I'm going to do, all right, I'm not going to do it now, actually. I'm going to go through it. I'm going to go through it properly and pick out the important parts. Okay, yeah, I'm going to do that. I'm going to end the chat. Anyone in the chat, I'm going to end, why is it called London Gen Zoom meeting? I changed this how many times? Okay, I'm going to edit that. Oh, that's annoying. I really need to get better with using the technology. I'll get there. Give me some time. But yeah, I'm going to end the stream now, and I'm going to try to. And I'll be back maybe later. I might get a couple other people to see if they want to jump on and join. There's no battles today. Or is that Survivor Series going down? I don't think there's a stream, is there? There is, I'll watch that, but otherwise, yeah, we'll see. So thanks for joining. Thanks for tuning in. If you're still here, hit the like, share this when it gets re-uploaded. And yeah, London Jen,